Good morning to our wonderful viewers. It is a pleasant time again this morning, joining us live from the grounds of the Temple of Justice in Monrovia, and we are currently situated right before Criminal Court C at the Temple of Justice. Criminal Court C face directly the headquarters of the Liberia National Police, and is the entrance that you use from Pinsville to access the grounds of the Temple of Justice in Monrovia. And if you look at the wall, there is an inscription that says, "Let justice be done to all men, without any prejudice," meaning with your status, your physical appearance, whether you are deformed, you are a wealthy person, or you are poor, let justice be done to all men. And this morning we are here. Today is Friday, the 28th of February 2025, and today is the last day in February 2025, and today is your birthday. Let me say happy birthday. But it's good this morning joining us. We are here, like we said, on Wednesday. The presiding judge of Criminal Court C at the Temple of Justice in Monrovia, Roosevelt Willie, is set to rule in a 10-count motion filed by defense lawyer representing former finance and development planning minister Samuel Tweh, former Solicitor General of the Republic of Liberia, Councillor Tweh, Moses Cooper, former Executive Director of the Financial Intelligence Unit, Republic of Liberia, standing for and former National Security Advisor to the immediate past President of the Republic of Liberia, George Weah Jefferson Camo. On the 24th of February 2025, there was a motion filed by defense lawyer held by Councillor Arthur Johnson, former Associate Justice Wiggins Wright, former LCC Executive Director Councillor Wabuduke, and others filed a 10-count motion before the presiding judge of Criminal Court C here at the Temple of Justice. According to their 10-count motion, their reliance is the new Security and Intelligence Act of 2011, to be particular Section 11F, which talk about security operations, and their reliance is the $6 million United States in questions were used for state security operation, and those who are currently in court, they should not be asked to account for the $6 million that they are currently in court for. And according to them, the money was used for security operation across the country. And that law says any form used for security operation should not be disclosed to the public. So it is based on that, defense counsel filed a 10-count petition saying that the former finance minister Jefferson Camo, standing for Moses Cooper, used ceremony for security operation, and they should not be prosecuted for said Sunday money. But prosecution is saying no, and prosecution team is held by the now Solicitor General of the Republic of Liberia, Councillor Augustine C. Fire, Councillor Jerry Galawolo, and you also have so folks that I was saying, the defense and the prosecution are currently in court. The former finance minister is currently seated on the prisoner bench. The former Solicitor General of the Republic of Liberia, Councillor Tweh, is also seated there. You also have Jefferson Campbell, the former National Security Advisor to President George Weah, is also seated in court. Stanley Ford is also seated in court, and Moses Scoper, the former Financial Intelligence Unit Executive Director, is also seated in court this morning, waiting on the ruling of the Judge of Criminal Proceedings, Temple of Justice Roosevelt Willie. So I'm going to read you verbatimly. The Defense Counsel reliance. I'm going to read you verbatim the Defense Counsel reliance. And also you have in court the County Attorney for Monrovia County, Councillor Richard Scott, is also in court this morning awaiting the ruling. So this reliance of the Defense Counsel, like I said, is the 2011 Act of the Security Reform that says every form used for security operation should not be disclosed to the public. And so according to them, the 6 million that they are currently being prosecuted for by the grand jury of Monrovia County were used during the Weah's regime for national security operation. That is their major reliance, and they are calling on the presiding judge of criminal proceedings, who resumed jurisdiction in this particular case based on a recusal of Judge Blambo Dixon. And Blambo Dixon was taken to the Supreme Court of Liberia. And Blambo Dixon, according to him, he has some link with the defendants, Samuel Tweh. So based on that, for conflict of interest, he was asked to recuse himself, thereby giving way to Judge Roosevelt Willie, who is the presiding judge of criminal court A at the Temple of Justice, to resume jurisdiction in this particular case. And this case is being held 3 times a week: Monday, Wednesday, and Friday. We were here on Wednesday. Both defense and prosecution argued the 10-count motion and Judge Willie reserve ruling for this morning, which is the 28th of February 2025, and we are here to bring you our count of the ruling. So folks, as we speak, Criminal Court C is jam-packed. There are no seats. For the few appearance, the lead lawyer of the defense counsel was not in court, but this morning I'm seeing the presence of Councilor Arthur Johnson, who a few weeks ago went to the International Criminal Court, the ICC, for assignment. He's back in country. He's currently in court, awaiting the ruling of Judge Roosevelt Willie. So folks, we ask that you kindly stick and still. This case is one of the cases that government placed key interest in. Mind you, a few weeks ago, the Supreme Court of Liberia ruled in favor of the Asset and Property Retrieval Task Force headed by Councilor Edwin Clark Martin, who happened to be the former executive director of the Liberia Anti-Corruption Commission. The Supreme Court ruled in favor, thereby granting the asset recovery team to go on with Assets and Property Retrieval Task Force to go after stolen property that was stolen by past government officials. And this task force cut across the country, and as we speak, there are teams that have been set out to visit various counties, capital in Monrovia, in Liberia, to know exactly some of the properties that people acquire all the time, to clarify how those properties were accrued in a very short period of time. So it also tells you that this government, held by President Joseph Yuma Boakai, has placed key interest in the fight against corruption. Every time people complain that corruption is on an increase in Liberia, so President Joseph Boakai has placed key interest in the fight against corruption. So this case is one of the landmark cases that will set precedent, that will set the path, that will set the path for the fight against corruption in this country. So as we stand, we are right outside, right before Criminal Court C, Temple of Justice, awaiting the ruling of Judge Roosevelt Willie. Like I said, if you look out here, outside the court is jam-packed. The courtroom is packed to capacity. So what I can tell you is, kindly follow LNTV Live Liberia, and also on your television screen as we bring you the unfolding right here from the grounds of the Temple of Justice in Monrovia, awaiting this 10-count petition, this 10-count motion, I beg your pardon, filed by defense counsel, calling the judge to dismiss the case, or the virtue of the fact that the 2011 Act clearly states that any form used for security operation should not be accounted for in any court of jurisdiction. But again, if you read portion of that Reform Act, it also talk about what was mentioned in section 3F in that law gave preference to only the presidency, not other government officials. So there have been questions based on the fact that the former finance minister, the former national security advisor to the president, the former FIU executive director, and standing for are asking the court to dismiss the case based on said fund our use on security operation. But when they were asked to tell exactly what were the particular security operation that this $6 million United States dollar in questions were used for, they were unable to clearly state or cite instances where this particular money was used. So, I mean, another questions that pundits continue to ask is that were there any instances during the Weah regime that Liberia faces any security threats that leads to the use of $6 million? I mean, you are Liberian. We are here. Apparently, something happened during the Weah regime. We can kind of drop it in the comment section so we can know. But to my knowledge, nothing of any major security threats or security threats happened during the Weah regime. That $6 million United States dollar were used for. So folks, kind of sticking still, we are here after this ruling. I mean, somebody asking whether we were at war by then. No, we were not at war. I mean, from 2018 to 2023, Liberia was very peaceful. People were going about doing a normal thing here. Regular school were in session. In fact, in time past, Liberia have been branded to be one of the most peaceful countries in Africa, based on the fact that we have had several successful elections, and this country has been so peaceful. There are no security threats, of which $6 million taxpayer money will be used on. And now they are asking court to dismiss case or to dismiss indictment against them based on the use of $6 million for security reasons. So I'm making effort to lay my hand on the 2011 Act, the Reform 2011 Act, to read it to you very tenderly for your consumption. I mean, Joseph Kennedy is saying maybe this $6 million was used for the COVID-19. And mind you, during the COVID-19, you have some use on the money that was used by then the Environmental Protection Agency Executive Director, Wilson Tappet, to give stimulus package, which when he was invited by the Liberian Senate to give outcome of the funds that were used for stimulus package, again he was unable to give the actual use of that fund and to give also a report to authenticate that yes, said amount was also used for stimulus package across the country. But we are here, all eyes, ears, a coroner here at Criminal Code C, Temple of Justice. Like I said earlier, the courtroom, the jail park, the defendants, the 5 defendants are currently in court. Both defense and prosecution are also seated in court, awaiting the ruling of this case. And from what we gather so far, after this ruling, this case is going to be a juror case. It's not a bench trial. A bench trial is determined by the judge who presides over that particular case. For a jury trial, you have jurors that have been drawn across the country that will be here at the grounds of the Temple of Justice until this case comes to the end. If this case will lie for 4-5 months, they will be here and their welfare will be catered to by the Ministry of Justice. So we are here awaiting the outcome of this ruling. We ask that you keep sticking still, don't go away, keep dropping your comments. When I return, I'll read to you the 2011 reform of the Security Act that are currently using as their rely. Yes, indeed, Daniel Bono says, let the law take a course. Yes, Daniel, the laws will actually. That's why if you just come here at the Temple of Justice in Monrovia, there is an inscription that says, let justice be done to all men. And it tells you that whether you are poor, you are rich, you have some challenges with your health, even if you are deformed, when it is in your favor, justice will prevail. When it's not in your favor, justice will also prevail. So we are here this morning awaiting a ruling of the 10th count motion filed by defense lawyer held by Councilor Arthur Johnson, who have been out for a couple of weeks, and he's now in country awaiting the ruling of the 10th count petition by Criminal Code 8 presiding judge, for who have resumed jurisdiction in this particular economic sabotage case of former finance minister Samuel Tweh, Jefferson Camo, Stanley Ford, and Moses Cooper, all served in the immediate past administration led by former soccer legend George Manen. So we are here making sure that we bring you play-by-play description as it unfolds here. Marco Camara say we are looking up to the court. Yes, Marco, we are all here awaiting what the court will say. We are still here awaiting what the court will say. But as it stands, we cannot prehend the reading. Both defense and prosecution lawyers are in court, and the defendants are currently in court. Samuel Tweh and others are currently in court. So folks, I'm still here waiting the outcome of this 10-count motion filed by Defense Counsel held by Councillor Arthur Johnson, and so former Finance and Development Planning Minister is one of the defendants. Councillor Samuel Tweh, former Acting Justice Minister and former Solicitor General of the Republic of Liberia, is also one of the defendants. D. Moses P. Cooper, former Financial Intelligence Unit FIA and controller. You also have Stanley F4, former FIA director, and you have Jefferson Campbell, former National Security Advisor to then President of the Republic of Liberia, Samuel Tweh. And they were accused of subsuming a huge sum of money that which they were indicted for by the grand jury of Monrovia County. And they were also indicted for money laundering, economic sabotage, criminal facilitation, and criminal conspiracy as well. So there are 2 main crimes that were committed by them, for which they were indicted for. So these are the crimes: economic sabotage, theft of property, money laundering, criminal facilitation, and criminal conspiracy, among others. So just come and think about it. So even if just in case, so just in case, right? Even if criminal proceed ruled in their favor regarding the use of the 6 million United States dollar for security operation, but you also have several crimes. You have money laundering, you have theft of property, right? And you have criminal facilitation, you have criminal conspiracy, meaning the 5 of them went together, they conspire against the government of Liberia, against the citizen, to use the 6 million in questions for their personal use. Another question is, were there any instance during the Weir's regime that Liberia faces significant, external attack for which 6 million of the taxpayer money were used? These are questions opponents continue to ask, and we are here awaiting the outcome of this 10-count motion filed by them. We are here awaiting the ruling. So folks, sticking still, I'm here along with Fabin Kuya, Aaron Talu. Fabin Kuya is also here. After the hearing or after the ruling, Fabin Kuya will come and give you exactly the unfolding right here in Criminal Code C at the Temple of Justice in Monrovia. So folks, from what we gather so far, Criminal Code C Judge Roosevelt Willie has ruled, and in subsequent time, Fabin Kuya, who was in the courtroom, will come and give you updates regarding the ruling of the presiding judge in this case, Criminal Code C, here at the Temple of Justice. From all indication, it seems to be that the ruling is not favorable for the defendants. From all indication and from the faces of those who are come in support of the defendants, it seems to be like the ruling is not in favor of the defendant. But again, we are still waiting. We are still waiting to have word with Fabien Kuya, who was in the coach room, to give us exactly the unfolding there in criminal proceed temple of justice. And we'll also make effort to speak with the county attorney for Monrovia County, Councilor Richard Scott, and we'll also make effort to speak with the current Solicitor General of the Republic of Liberia, who is hearing this particular case against the former finance minister, Councilor Augustine C. Fire. We'll also make effort to speak with him, and we'll also make effort to speak with Councilor Jerry Galawolo, all who hail from the Ministry of Justice, who are prosecuting the former finance ministers in full order for stealing over $6 million United States dollar from the taxpayer account. So folks, we are still here, like I said earlier, from our sources in court. The ruling, it seems to be not in the favor of the defense lawyer. According to them, the reliance, which is the 2011 National Security Reform Act, it is clear that whenever there is a misuse of government fund, those who are found misusing cell phone cannot be held liable or cannot be taken to court while they are still in power. But when they shall have leave power, the state have the right to take them to court to account for, and only the president is exempted for such acts. But as it stands, there over 500,000 that were used in questions by the former Finance and Development Planning Minister Samuel Tweh for the purchase of IT equipment for the national security, that is NSA. There's no document, there's no record to actually show that 500,000 United States dollars were used by the immediate past finance minister to purchase IT equipment for NSA. There's no record to that effect to trace. So when the supporters who are come in favor of the defendants for the local things and for what we're gathering, it seems to be that the ruling is not in their favor, but we are also being informed that this ruling is not in their favor. They will be taking flight to the Supreme Court, and after the Supreme Court, they will return back to criminal proceeding for the continuation of this case. Mind you, this case has not yet started. This case has not yet started. They are still waiting for the motion hearing. After this 10-count motion hearing, the case will commence. So in this case, it's a jury trial. It's not a bench trial. A bench trial is only determined by the judge. The jury trial is determined by the juror who have been chosen from across the country, from across government, ministry, and agency to come and sit and listen to the magnitude, merits, and demerits of the case. So the defendants are now making their way back. Former Finance and Development Planning Minister Samuel Tweh, Jefferson Camo, standing for Moses Scopo, are now making their way out. Out of criminal proceed at the Temple of Justice, meaning after ruling into a 10-count motion filed by a defense lawyer held by Councilor Arthur Johnson, and the prosecution team is held by the current Solicitor General of the Republic of Liberia, Councilor Augustine C. Fire. So here comes councillor. So this is the councillor. So Councillor Tony, well, most of the councillor Richard Scott.
No, just councillor.
Councillor Fire, good morning.
How are you?
I'm seeing you are in a smiling mood. How was the 10-count ruling?
I don't smile when I come to court.
Okay, so how was the 10-count petition ruling?
I think it was all right. The ruling was all right. It was okay. The judge has spoken.
Okay. I mean, could you just, if you say you're all right, what are you trying to say? Was it in your favor or not?
I think it was in my favor. The motion, the file was denied. We should prove the case, and we prove the case. We have preponderance of evidence. We have more than evidence, so we prove the case.
Now
Sufficiency of evidence is beyond, because they themselves are the evidence. They did not deny. They said they took it. So what is it that we need to prove again? It's only for us to appear to court. They said they took it, but they took it under the security, umbrella. So that's it.
But don't you think the argument to the court on security ground, national security, is justifiable? That's why the court ruling.
You were there, you listened to the ruling. There was nothing streamed. It was not done properly. Where is a financial intelligence agency part of the joint security? Look at the law. Look at all the law. They are never member of the joint security. So that is self-defeating. If you ask some of the defendants that there, they will tell you, say, we are not member of joint security. So what is there to be proved? They have made the case for us.
From the court ruling, they took an exception to the rulings, probably they could be taking flight to the justice.
I think that's a bluff. I think that's a bluff. They themselves know that they can't go anywhere. Nowhere they will go. They took the money and they will bring it back. They took the money and they will bring it back.
So are you not trouble on the appeal? Probably they could take to the full bench.
Where you don't scare the fish with the water. That's where we are. I'm prepared for everything. You don't scare the fish with the water. That's where we are. Okay. So the case, no place to hide. No place to hide. They cannot hide. They will bring the money.
Okay, thanks a lot. Thanks a lot. Yes, the Solicitor General of the Republic of Liberia, Councillor Johnson.
Welcome to the media.
Councillor Johnson, good morning.
How you doing, gentlemen?
What do you know of today's ruling?
Well, today's ruling, we know that the judge has scrapped onto himself an authority that he doesn't have. When specific provisions of the Constitution are raised as subject matter of discussion in a trial, a court of limited jurisdiction, specifically a trial court, does not have the authority to interpret the Constitution. That authority is ascribed to the full bench of the Honorable Supreme Court. To date, the judge had indeed agreed that the former officials of government are immune from any criminal prosecution or judicial inquiry for acts committed or acts carried out while serving as members and statutory members of the National Security Council and principal advisors and agents of the presidency. That immunity of the president that extends to the advisors of the president and the agent, that immunity can never be subjected to judicial review in a court of law. The courts shall refrain from conducting inquiry on the basis that any attempt will compromise national security. In fact, it's on the other way around. Why we should be protecting the protection of national secrecy, I see the government proceeding to expose national security operations, especially about expenditure during elections to keep this country safe from threats to the elections.
Also, if you agree that the judge ruled against you, if you agree that the judge in his ruling admitted that it was right for them, why did he rule against you and then he took an exception to the Supreme Court?
Is that with the wisdom of the judge? The next thing is the defendants, the former ministers of the former officials of government cannot stand trial. Why? Under the due process clause that we have in fact our cases like the Wallow versus Wallow, the landmark case on due process, before you are convicted, you have the right to question the witnesses, to produce evidence in your favor in order to exonerate yourself. These officials are prohibited by law not to defend themselves. And what is the law? The National Security and Reform Act, Intelligence Act of 2011 says as long as they are alive until 20 years, even if they go for trial and they take the witness stand to testify about how they expended the money, when they come outside, the NSA will arrest them also because they have breached national security intelligence operation. That's why you take off on the level at the level of the National Security Council.
So in short, Council, are you saying that the judge erred in his ruling against you people?
The judge erred. And in fact, the ruling went beyond the scope of authority of the court.
Meaning that you are taking flight to the Supreme Court for your account?
Well, the team will discuss that. But what we know is that the law already gives us the authority to go on the remedial process when the judge had made a decision, especially on the issue of authority, that he had gone beyond his authority. The judge, the trial court, has no authority. And that is a standard established by the Honorable Supreme Court by years of horror with age, that whenever constitutional issues are squarely raised, no court of law has the authority to determine and pass unconstitutional arguments beside the full bench of the Supreme Court.
The judge did quote Article 51 of the 1986 Constitution as it relates to people being immune and exempted.
Under Article 61 that talks about immunity of the president. 61. No, it's 61. It's 61.
And not 51.
It's not 51, it's 61. Under Article 61 of the Constitution, the president is immune from all prosecutions. The only time the president is not immune from prosecution, it must be certified by condition precedent. What are those conditions precedents? The condition precedents are the president must first be impeached and removed. Any leader in this country who has never been impeached and removed, every act or acts that he conducted or carried out or he assigned to his agents while serving as president, that extension of immunity covers them, and you cannot question those agents. This is the argument before the Supreme Court that will soon be appearing. Whether or not an agent or an advisor of the president serving at the level of the National Security Council, which they are creating the National Security Council, prohibits him that you cannot take the stand to testify on national security matters that have not been declassified. As we speak, the expenditure of the former government to maintain a peaceful transition, to divert and abort the threats to national security and the elections of 2023, the government presently had never declassified that information. Any of these officials who comes to court and to testify how that money was expended, who the agent that received it, and what area they assigned the agents for what purpose, they will go to jail. So you see the dilemma that our clients have. So we are saying this is a serious landmark argument. The first time that will be appearing before the court or the Supreme Court for the court to determine whether agents and advisors of the National Security Council who operated under the ambit of authority of the president can be subjected to judicial review. No money was stolen here. Thank you.
So that is Councillor Arthur Johnson speaking, and we are still here. This is the Liberia National Television. And so we earlier on you. So folks, we are still here. You just listening to Councillor Arthur Johnson, and earlier on you listened to Councillor Augustine C. Fire, who is the current Solicitor General, and he is the lead prosecution, and Councillor Arthur Johnson is the lead lawyer representing the defense team. You listen to Councillor Arthur Johnson that they are taking flight to the Supreme Court of Liberia. So folks, we would love to say thank you so much. We love to say thank you so much, and so both defense and prosecution team already is getting ready to depart the grounds of the Temple of Justice in Monrovia. We love to say thank you so much for following this. Right before Here is the former finance and development planning minister, Samuel Tweh. You also have Councillor Nyanati Twine. You also have Stanley Ford. You have Jefferson Kamo and Moses Cooper, all who have been in court. And like I said earlier, criminal could see George Roosevelt Willie have ruled in favor of the government of Liberia, thereby denying the 10-count motion filed by defense counsel to dismiss the case based on the use of the $6 million United States dollar in question for national security operation. So this vehicle right here belongs to Councillor Arthur Johnson. Councillor Arthur Johnson is the lead lawyer representing the defense counsel. So folks, thanks a lot. Thanks a lot. So folks, again, thanks so much for following us. This particular vehicle belongs to the former finance and development planning minister, Samuel Tweh, and all of who are currently put for the use of $6 million United States dollar, according to the former finance minister and all of the $6 million in questions were used for security operations, and therefore they cannot be held liable for the use of said fund for security operation. And the 10-count motion filed before criminal could see George Roosevelt Willie have been denied, and Councillor Johnson and others have announced taken flight to the Supreme Court of Liberia for the Supreme Court of Liberia determination in that 10th count motion file. So thank you so much for following. We appreciate you. We say thanks a lot for following. And I've been here with Fabi Kuya.
Spoon TV.
So basically today at Criminal Court C, we came here to hear the ruling in a motion to dismiss indictment that was proffered by lawyers representing Samuel Tweh and 4 others. Judge Roosevelt really denied the motion to dismiss the indictment against the 4 officials on several grounds, because the argument was that they are part of the National Security Council and they are immune or they are exempted, which of course they cannot be held accountable for anything that will be said and stated the Act of 2011 that created the NSA. But Judge Welle also quoted Article 51 of the 1986 Constitution saying it's only the President of the Republic of Liberia that can be immune or exempt from some actions while the person is in office. But while they are out of office, they can be prosecuted, and so because the phones weren't authorized and there were no documents to prove that phones were being used for its intended purpose, therefore they should be prosecuted. And I remember in court when the judge denied that motion to dismiss the indictment against him, defense team took an exception to the Justice in Chambers, which of course afterwards Judge Welle told the court that indeed the case will commence on Monday.
So, I mean, Fabian, we listen to Adler Johnson. According to him, the judge erred in his ruling. On what basis, I mean, he was speaking?
I mean, Councilor Johnson, obviously, he's defense lead lawyer, and in most instances, you know, they will always have to defend their clients, and so he had the right to say what he said. But whatever the case is, was that the judge did quote Article 51 of the 1986 Constitution, and then after Johnson said he was misled, instead of 51, it should be 61, where the judge quoted that portion. And as I said earlier, as defense team lead lawyer, definitely you don't expect him to say who a prosecution, but rather you will always say the best to defend your clients.
I mean, this is my last question. How was the appearance of those defendants, more especially the former finance minister?
At a point in time, while they were seated on the prisoner's bench, you can see the former finance minister Samuel Tweh and the former Solicitor General Councilor Tweh going back and forth. Either the continent showed that they were in some disagreement with the judge's ruling, because at a point in time you can see both of them with their hands going back and forth. But there's nothing they could do while seated on the prisoner's bench, because they had a team of lawyers representing them.
Great. I mean, you spoke about Supreme Court. How soon we hope to see?
Well, they announced an exception immediately after the judge's ruling, and so we expect them to maybe start the process by Friday. But after announcing an exception, Judge Welle told the court that nothing will stop them. On Monday, the case will commence. And again, Aaron, I think there should be jury selection in this case, because I'm hearing that there's going to be a jury trial and not a bench trial initially. So once there's jury selection in this case, obviously they will be sequestrated, meaning they will be kept at the basement of the Temple of Justice for how long the case will take. So we are waiting to see the jurors that will be selected for the case.
How soon will the selection process begin?
Well, probably it could be today, because obviously they were waiting on the decision of the court either to grant or deny this motion to dismiss indictment. Now that it has been denied and they took an exception to the judge's ruling, probably it's going to take some time. But remember, as I said, Judge Welle said on Monday this case will commence no matter what.
How many jurors are we talking about, if you are just told?
Probably it could be more than 12 or so.
Thank you so much.
12 or 15%.
Thank you so much.